Greetings, I'm Glenn Witecki from the Witecki Law Office in Schenectady. We've done a number of segments, video segments for you on wills and trusts and how they compare and contrast and so forth. And one of the reasons you do a trust is to either avoid will challenges, avoid the probate process, but there are some times where you're not expecting a challenge to your will, but nevertheless, a probate process is just difficult to go through for practical reasons. And let me give you one quick war story that I think will describe it and you'll understand it completely. So, as I've said in other segments, if you pass away with a will, in order to understand who can object to your will, you have to understand who would inherit your estate if you didn't have a will, because the people who would inherit if you didn't have a will are the ones who have a right to challenge the will, for reasons explained in other videos. So, and a more specific example is if someone passes away with no spouse or children and no parents, then their brothers and sisters inherit their estate. So some years ago, I represented the estate of a 98-year-old woman who passed away, and she didn't have any children or a spouse. Obviously, her parents were deceased, and her closest relatives were brothers and sisters, but the issue was that she was 98 and she was the youngest of 8. She had 7 older brothers, and she was born in Estonia in Eastern Europe. So to make a long story short, before we could get the will probated, we had to establish for the court that all 7 of her siblings were deceased, and then some of their children were deceased, and we had to go all the way down on each of their family trees to the extent that they had children to find the current living relatives, and they were the ones who had a right to challenge the will. None of them did. They didn't really even know our decedent here, but we couldn't get the will through court without doing that. And since she was born in Estonia, and since she was so aged and elderly and her brothers were all older, several of them actually died in World War I. So we had to hire a lawyer to look at World War I death archives in Russian and Estonian languages. So I could go on, but I won't. The point is, where you have a family tree, whereby even if you don't expect a will challenge, where the closest relatives, the ones who can object, are either long since passed away, maybe they're in Europe or some other part of the world, maybe you've lost contact with them, you don't know where they are, you don't know if they're dead or alive. It's a really good reason to do a revocable trust, because the trust does not have to go through the court system. You don't have to look for the closest relatives in order to administer the trust. And as soon as someone passes away, you have a trustee named right in the trust who, without going to court, has authority to administer the assets of the trust. So the Estonian example is an extreme one, but we have many folks who have their closest relatives in England or Germany. We've had situations like this a number of times, and you really should do at least a revocable trust where you keep control of your assets, but you're not held up by someone having a right to challenge your will. Thank you.